as well. So to me, being moral means doing what's right for the community. And one would hope that the government is moral, that it's doing the right thing for the community, for everyone. Liberty is the ability to do what you want to do. And in general, things that consenting adults do together, particularly in private, are neither moral nor immoral. It's what they want to do. And one would hope that the Supreme Court and the government as well would protect these sort of things. The Supreme Court, it is not the job of the Supreme Court to define morality or to protect liberty. The first sentence of the Constitution, after the preamble, states, all legislative powers herein granted shall be vested in a Congress of the United States. The representatives, the elected representatives of the people, and they're the people who we hope will pass laws that help morality and protect the liberty of the people. The Supreme Court is there to interpret laws. They cannot make laws. In the early 1960s in Connecticut, the people apparently thought that dueling to defend one's honor, prostitution, gambling, and the use of marijuana were all immoral because they made those things illegal. They also thought, apparently, that having sex just for the fun of it, with no intention of procreation, was also immoral because they made the use of contraceptives illegal. Not everyone in the state of Connecticut thought that that was a good idea. And it eventually became the case of Griswold versus Connecticut in 1965. And the court in Griswold said that the law against contraception was unconstitutional because it invaded the right of privacy in the Bill of Rights. Now, there's no mention of the right of privacy specifically in the Bill of Rights, but the Supreme Court said that the Bill of Rights is more than just what it says there. There are emanations from the Bill of Rights, and those emanations have penumbras. And it's in those penumbras of the emanations where the right of privacy can be found. That might sound like a bit of a stretch, but the court said that in the Constitution, for instance, there's a right of free speech, but there's no right to listen to the speech. There's a right of freedom of the press, but no right to deliver newspapers and spread them around. And the court said those things are obviously there. And likewise, the Third Amendment says that you have a right to have your house free from quartering of soldiers. The Fourth Amendment says there are no unreasonable searches of your houses or possessions or anything else. And the Fifth Amendment says that no one can demand of you to say what's on your mind or even to say what you've done. And there's the Ninth Amendment, which says that there may be certain rights in the Constitution which are named and numbered, but those are not the only ones. There are other ones there, and those rights are reserved for the people. So gathering all these things together, the court said that there is in the Bill of Rights the right of privacy. And what could be more deserving of privacy than intimate sex between consenting adults? 2 years later, in the case of Loving versus Virginia, there was a law in Virginia that said there was no sex allowed between people of different races. And the court just applied the ruling in Griswold and said that law is unconstitutional and it's protected. That sex between people of different races is protected by the right of privacy. In 1986, in the case of Bowers v. Hardwick, there was a law in Georgia which said that sex between people of the same sex, homosexuality, was illegal. And the court said that concerning the right of privacy, it doesn't cover homosexuality. And sodomy has been illegal for hundreds of years. Well, it took 17 years before the court got another chance to speak on that subject. And it was in the case of Lawrence v. Texas. And the court said that the Bowers decision about homosexuality was one of the worst decisions that the Supreme Court had ever made. and the right of privacy covers homosexual sex as well. In between these three cases came Roe against Wade about abortion. And the court said that in spite of the fact that abortion covers things that are not people and things that are not just adults there, and there's no possibility for consent in this case, they said that the right of privacy covers abortion. But they added a lot of details as well. They said that in the first 3 months of pregnancy, there's an absolute right of abortion, abortion on demand. But in the middle 3 months of pregnancy, the states could modify the right of abortion, which is a strange idea. State legislatures could modify federal constitution. Anyway, they said they could have certain items that they wanted to know, like doctors, different kinds of procedures, and et cetera. But they didn't have to do that. And then in the last 3 months, the states could completely ban abortion if they wanted to, but they didn't have to. So in effect, what the court said was, in the Constitution, there's a 3-month right to abortion. And after that, abortion is okay, up until the point when the fetus takes its first breath and becomes a person under the Constitution. All these details, supposedly in the Constitution, are the hallmarks of legislation. The court did what it was not permitted to do. It effectively created a law to conform with its sense of what was good for the people. They were legislating about what they thought was the moral thing. Last year, in 2022, there was a case, Dobbs v. Jackson Women's Health, in which the Supreme Court said, actually, the emperor has no clothes. States and the Congress could create a right of abortion, but there was no right of abortion in the Constitution, and Roe v. Wade was overruled. Before we congratulate the court on finally telling the truth and clarifying the role of the Supreme Court, I want to talk about another case also decided last year about prayer in the public schools. The First Amendment of the Bill of Rights says, Congress shall make no law regarding the establishment of religion, or prohibiting the free exercise thereof, or abridging the right of freedom of speech or of the press, or of the right of the people peaceably to assemble, to petition the government for redress of grievances. The first clause of the First Amendment of the Bill of Rights talks about the separation of church and state. It's called the Establishment Clause, and it was Thomas Jefferson who first called it the separation of church and state. But is there really a separation of church and state? There's a chaplain for the Senate, and there's another chaplain for the House of Representatives, and both of them are paid by your taxes and mine. Every year, there's a national prayer breakfast at the White House. All of our coins and bills have either stamped on them or printed on them, "In God we trust." There's under God was inserted into the Pledge of Allegiance. The Supreme Court, when it opens every session, the clerk calls out, "God save the United States and this honorable court." And there are monuments all over the country, hundreds of monuments built with the people's tax dollars, state monuments and federal monuments, in which many of them are in the shape of Christian crosses, and they have inscriptions on them alluding to God and religious things and prayers and stuff like that. So is there really a separation of church and state? The Supreme Court has said the kind of things that I just mentioned have a long history and tradition, and no one has to do anything special. You don't have to get on your knees when you see one of these monuments, and you don't have to read the dollar bills. You can just use them to buy your groceries. However, in the case of public schools, the court has said that there will be a strict separation for two reasons. One, we're not dealing with adults. These are impressionable children. And also, the children can't avoid going to school. They have to be there. It's the law. In 1948, in Champaign, Illinois, the schools there had 1 hour a week in which they invited religious instructors to come into the school. And for those students who wanted religious instruction and whose parents asked for it, they could get religious instruction during that 1 hour. And for students who didn't want to have religious instruction, they could stay in the class and keep on with reading, writing, and arithmetic. Well, the Supreme Court said, there's no religion in schools. You can't invite religious instructors into public schools. And that was the end of that. This reminded me of my own acquaintance with the public schools. I was going to public schools in the late 40s and the early 50s, but my family was a little bit different. My father was Jewish and my mother was Catholic, and I was brought up in no religion, not atheism, but no religion. And it was a bit awkward to me because my classmates would say, hey, Larry, what's your religion? And I really didn't have a simple answer. And like most children, I think, I wanted to be part of everybody else. I didn't want to be kind of a guy that's in the corner someplace or different from everywhere else. And I know that if my school had this situation, as in Champaign, Illinois, when the hour came for religious instruction, I'd be the only kid left in the class. And I would feel miserable, and I would run to the nearest religious education that I could get to. In 1952, there was a case with the New York State Board of Regents. The New York State Board of Regents wrote a non-denominational prayer, whatever that might mean, to be recited by the students before class every day. And for those students who didn't want to be there, they had permission to leave the classroom during that prayer. And the court said two things. It said, number one, what was the Board of Regents doing writing prayers? There's no religion in the public schools. And as for the supposed ability of the student to leave the class if they didn't want to be there, another way of saying that, which might be the way that it would be said to and by the students, is if you don't like our prayers, you can leave, which is not the sort of attitude we want to have in our public schools. In 1978, the legislature of Alabama passed a law that every morning in school, there would be 1 minute of quiet meditation. And 4 years later, they modified that law. They said, you know, that 1 minute of quiet meditation, the students can either have meditation during that 1 minute, or they could say a silent prayer. And then the year after that, the legislature said the teachers can lead prayers among willing students. And of course, those people who didn't think that that was a good idea, they could leave the classroom. And the court considered all of those laws and modifications in the same case. They said, number one, the teacher cannot lead prayers. There's no prayers in school. And the second thing they said was that the suggestion by the legislature that a student could say a silent prayer during this minute, they couldn't do that either. There was no suggestion of religion in schools either. The 1 minute of quiet meditation, that was fine. In 1992, in Providence, Rhode Island, the principal of the middle school contacted a religious person. In this particular year in which the court did it, it was a rabbi, and asked the rabbi to give a benediction at middle school graduation. And please, Rabbi, make it a non-denominational benediction. And the court said, oh, by the way, I've got one other important part of this, which is that students didn't have to attend graduation. They would get their diploma whether they attended graduation or not. And the court said that graduation is a school function and there's no religion in school functions. And the idea that a young person for whom graduation was the big event up to that point in their life, they are not going to stay away from graduation. It's something that everyone is entitled to. there's no religion in school functions. And I have another story to say about this. I remember my high school graduation, and I remember there was a benediction there, but I wasn't really paying attention at that time in my life to what was happening at school. And I didn't pay much attention to the benediction either. But 3 years later, I was in college, and my brother Rick graduated from the same high school. And I went to his graduation with my parents. And I was rather taken aback when the first thing that came out of the PA system for the graduation is, "All please rise for the benediction." And I thought pretty intensely for about 3 or 4 seconds. And I said, "I'm not going to stand up." And the people around me, what they said, it was almost overwhelming. There were people looking to me with strange looks on their faces, screwing their faces up. And I heard one person say to another, "Is he a communist?" And another person said, "I hope he stands up for the national anthem." And my mother, very embarrassed about my actions, said in a stage whisper, "You stand up." But I held my seat, and I realized that my brother, or one of the students in his class, would take an enormous amount of internal power if they had the same feeling that I did, if they would stay seated. It sounds like an impossible thing. In 2000, in Santa Fe, Texas, yes, it's Texas, Santa Fe, Texas, the students themselves voted for having prayers at football games, and they chose one of their students, one of them among them, who would choose the prayer and say the prayer over the PA system before football games. And the court said that athletics are a school function, and there's no religion, there's no prayers at school functions. So I've gone through several cases here just to show the many ways in which people have tried to add religion into schools, different times, different ways. And there are many more such cases. 74 years from today, this year, for 74 years, the court has said that the separation of church and state will be strict in the case of public schools. And in 2002, last year, there was the case of Kennedy versus Bremerton School District. And I'm going to read a quote from the official opinion of the court. "Joseph Kennedy lost his job as a high school football coach because he knelt at midfield after games to offer a quiet prayer of thanks. He offered his prayers quietly while his students were otherwise occupied. The Bremerton School District disciplined him because it thought anything less could lead a reasonable observer to conclude mistakenly that the school endorsed Mr. Kennedy's religious beliefs. The Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike." Almost everything in that paragraph is untrue. Kennedy did not lose his job. He was put on paid administrative leave while he and the school board could come to some compromise as to how Kennedy could follow his religion and the school could follow the requirements of the Establishment Clause. Kennedy refused to make any compromise, and he walked away from his job. Could I have photograph A, please? As you can see in this photograph, he didn't say his prayers alone, and his students weren't otherwise occupied. There was a fence around the field. The football field was not for the public. There was no public access to the field. It was just the teams, the coaches, and the officials. And a reasonable observer would be entitled to think in this situation that the prayers were endorsed by the school. And there was a Satanist group that demanded to have their chance to say prayers in the middle of the field at the next football game. And photograph B.
I'm not sure Joan heard you, Larry.
Oh, well, it's ready. I'd like to, yeah, here we go. This is good. Thank you very much. Now, this is A. I want B. It's just, I'll keep talking because it'll explain the picture. When the school board told Kennedy that he had to stop what he was doing, he refused. He went on social media and gave 2 interviews in which he stated that he had a right to say his prayers the way he was doing it. And at the next football game, he was going to say his prayers again. And if the picture doesn't show up, I'll tell you what's in it. There's another crowd of students in there. And you also see people with photographs standing up. That's the press that was there. And there are also people who have jumped over the fence or climbed over the fence to get to join the prayer service as well. The court's platitude concerning respect of religious and non-religious views alike was a red herring. Kennedy was not stating a religious view. It was not a history lesson or a social studies lesson in religious views. It was religion itself. It was a prayer service. And what the Constitution and the best of our traditions do counsel is separation of religion from government. It was plain to the framers of the Constitution, as it is to us today, that religion and sectarianism have been the cause and continue to be the cause of some of the most obscene violence in human history, which is the reason why the framers of the Constitution made the Establishment Clause the first clause of the First Amendment of the Bill of Rights. And for the past 7 decades, the Supreme Court has made this a strict separation in the case of public schools. But the court in Kennedy versus Bremerton said that the free speech clause and the free exercise clause, when combined, overruled the Establishment Clause, and that Kennedy had the right to say his prayers in the way that he had been doing it. Stare decisis has been the rule of courts for centuries, predating the existence of the United States. It's a Latin phrase that means to stand by what has been decided. And it means that a case that's decided today should have a similar result to a similar case in the past. In other words, following previous cases, which means stability in the case of the law. And it also helps out with another thing that's called the rule of law, which means the rule of what has been written down, as opposed to the law of the people who happen to be in power, what they say the law is. When the court feels that it cannot follow precedent, it has the duty to give a complete explanation of why the previous cases were in error and why this case is the proper case. In Kennedy versus Bremerton, the court claimed that it wasn't changing anything. This has always been the way that things are. They said that I'm looking here for my thing here. Hold on. Yes. In my search, this was the first case that I found in which the court said that the right of freedom of speech and the right of free exercise of religion outweighed the Establishment Clause. These 3 items are signature parts of our democracy: free speech, free religion, and the freedom to have a government that's not of any religion. It's everyone's government. And these things do come in conflict with each other, but when they do, they require a balancing act, and not just saying that, well, it's 2 against 1, so the Establishment Clause loses. The court's distortion of the case, the distortion of the facts of the case, and the neglect of its duty to follow previous cases or explain why the previous cases were in error, was not were not innocent mistakes. They were intentional. There's only one person in 1,000 who would read the court case. Excuse me, I've got something else here. The photographs that I showed you, the court was aware of this. I took these photos from the record of the court. And also, the court also explained in different sections in the dissent that Kennedy walked away from his job. He didn't get fired. What unites this case, the case of Kennedy versus Bremerton and Dobbs v. There's the picture showing the people behind. And you can see the people with the cameras and taking pictures of it, the media, and etc. And everybody's saying prayers in the middle of the field. What unites the case of Kennedy versus Bremerton and Dobbs v. Jackson Health, where Roe versus Wade was overruled, is that they were both decided last year by the same conservative court. In both cases, the court did what it felt like doing. In one case, following the rules worked for them. In the other case, ignoring the rules was the way to go. The court is playing with fire. This is a dangerous thing, and I, for one, am worried.